cheque was misplaced should be proved by cogent evidence, not by bare statement. Delhi High Court. Case law. Pipe Lawkam. ORG. The Delhi High Court on Monday, the 4th of September 2017 in Bansal Plywood vs. State said that if the bare statement of the accused stating that the cheque in question bearing signatures and date was misplaced is taken as gospel truth, then all accused persons under Section 138 of the Negotiable Instrument Act can easily get away from their legally enforceable liability by taking such sham and false defense. Justice Vinod Goel observed that the respondent had been taking different stands at different stages of the proceedings, and as such the deposition is not at all worth inspiring confidence. The respondent, having adduced no other evidence, is not able to rebut the presumption under Section 139 and Section 118 of the NI Act. Not brought forward evidence which would have made a reasonable and prudent person believe that the explanation put forward was the most probable outcome. The bench also observed that the initial burden of proving that a legally enforceable debt did not exist against the accused lies on the accused himself, which has to be discharged by bringing on record some cogent evidence to make the court believe that the existence of such liability was not probable. The complainant was only required to prove that the cheque issued by accused was dishonored, and the statement of complainant that it was issued by the accused against the liability/debt is sufficient proof of debt or liability, thus shifting the onus to the respondent to rebut by way of cogent evidence and not by bare statement. When person appears in the court as a witness, he is required to state facts on oath under Section 4 of Oaths Act 1969, and his examination in chief is tested on touchstone of cross-examination by the other party. This is actually the evidence. Therefore, the plea taken in application under Section 145(2) of NI Act or defense taken at the time of framing notice under Section 251 of Code or explanation under Section 313 read with Section 281 of the Code by any stretch of imagination cannot be treated as evidence. This is only a defense which should have been proved by cogent evidence to rebut the presumption under Section 139 and Section 118 of the NI Act, the bench said. For more details, log on to www.lawkam.org.